Hi, and welcome to another episode of Real Legal Talk. I'm Jen, and this is Joette from KEILY, Mira, and we're here today to talk about terminations and releases of deposits.
Two main issues that arise when it comes to deposits, but the first one that we typically see is buyers and sellers think that once a contract is terminated, that the money automatically gets released, and that's not necessarily the case. Even though the contract may say that, you have to have mutual consent between the parties. So both buyer and seller need to agree as to who's going to get the deposit and as to how much. Is it the whole amount or is it partial? So that's definitely the first issue that we see, and that takes some negotiation between the parties oftentimes.
And it happens all the time. We always hear from either a seller who's like, this buyer decided to walk away, when can I get my money? Or the seller wouldn't agree to certain things, when can I get my money? And it's a very common expectation that the second the deal is dead, money should be coming back to somebody. So that's definitely the biggest initial shocker that we deal with clients. That's not how it works. There are two components to every termination. There's the actual termination of the contract and then the release of the deposit money. And those are two different issues. And they're actually, if you're looking at the Greater Hartford Association of Realtors form, that's called the Termination Release of Deposit form, there are two different sections entirely on that form. The first, where either a buyer or a seller can unilaterally terminate the contract. And
under certain circumstances.
Under certain circumstances, right. And then the second half that relates to the release of deposit money. So first and foremost, any party to the contract can terminate. Once that termination is received, the contract is terminated. The issue of the release of the deposit is an entirely separate issue.
It's important to note that when a buyer or a seller does terminate, it does not need to be countersigned by the other party in order to be valid.
That's why when we say that a party can unilaterally terminate, that's what we mean. And the other thing to consider is that second part of the termination form relating to the release of the deposit does not prevent a seller from relisting the property. So oftentimes where we see issues is in the consent or the agreement between the parties in how deposit funds are released. And a seller does not need to wait to have an agreement reached, particularly when sometimes a court order is required if parties really can't reach an agreement. The seller does not have to wait and leave their property idle just based on deposit money and not having an agreement on where those are going to go.
So it's important to note in the situation that Jen is talking about that the contract has been terminated either by one party or both parties, and the only remaining issue is to who will receive the deposit. And if that is the case, then the seller can still relist the property and the deposit issue can be settled at a later time.
We've had transactions where contracts have terminated, properties have resold, and we're still fighting over where deposit monies should go from prior potential purchasers and contracts that were on that particular property. So it's certainly, and it wouldn't go to mitigating damages either. A seller who's trying to prevent further loss should be able to relist their property without waiting for a deposit on a prior contract. So this is a very common issue, a very important topic for everybody to understand, that again, there are two components to this, and that the release of deposit is usually, unless agreed to by all parties, usually a lengthy process.
Please let us know if you have any questions. We're certainly here to help you when it comes to this issue or any issue that you may encounter in a real estate closing.